to episode 14 of Call to the Bar, International Law Over Drinks, a series of informal conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm Ntina Tzouvala, Associate Professor at the ANU College of Law. And this afternoon, I'm joined by our usual host, Professor Douglas Guilfoyle of UNSW Canberra. And we are going to talk about his current work on legal statecraft, and in particular, small states and the law of the sea, which is indeed why we have switched the usual roles. However, before we get into it, I must ask our traditional first question. Douglas, what's your drink?
Well, it's mid-afternoon in Canberra, so I haven't been bold enough to go for anything alcoholic, but I have broken back into my sampler set of Korean herbal teas, and I'm having something called, I'm going to mispronounce it, Meiwa flower tea, which is quite pleasant.
Is it nice? Okay, great.
And you, Dina?
So I'm in Sydney where summer has arrived, so I am drinking coconut water with a lot of ice.
Oh. And from a glass that looks a bit like a pineapple as
well. Apple,
yes. Podcasting being a visual medium, the listeners will obviously enjoy that.
That will make sense to everyone.
Yeah.
So, Doug, I wanted to talk about your work, both because a few episodes ago we talked about mine, but also because in the past few years you have been focusing your energies on one particular project, which concerns small states litigation and legal statecraft. And I also need to point out, because Doug is humble and will not, that he's doing so funded by an Australian Research Council Future Fellowship. And to those who are listening in and are not Australians, Future Fellowship is a big deal. So first things first, Doug, I'm really interested in the terminology that you use in this project. And in particular, I'm interested in the fact that in this project and in your work in general, you avoid using the terms lawfare or strategic litigation, opting instead for the term legal statecraft. Can you explain to us what do you mean by legal statecraft? You know, that's a really interesting term. And also, why do you consider it preferable over, say, lawfare?
Right. Okay, thanks. Look, it's a terrific question, and it's something I wrestled with at the beginning of the project. So I originally defined the project as small state strategic litigation and the law of the sea. So I started with this terminology of strategic litigation, or indeed lawfare, but it's a very slippery set of kind of concepts and rhetoric. And the sort of light switch went on for me when I read a book review by Michael Becker of one of the key works in the field, Kittry's book, Lawfare, where Michael just sort of said offhandedly, you know, the difficulty with a term like lawfare is that it's very hard to define where the ordinary business of law stops and lawfare begins. And there is this risk that lawfare is an irregular verb, right? You know, I engage in litigation for proper purposes. You have some slightly forward-leaning arguments. They are engaged in lawfare. So there's that sense that, you know, it's potentially just used as a pejorative, but it does encapsulate at least one useful idea, which is that there are ways that law can be used, particularly by weaker parties, to advance their cause. But a lot of the literature I found was sort of taxonomic or descriptive, like here are the categories of lawfare, here are the ways it can be used, and it doesn't tell us an awful lot about why it's effective or indeed where that boundary line is. Strategic litigation, on the other hand, I think is slightly less pejorative, though it can be, but there's still this sense of, well, there must be ordinary litigation and then there's strategic litigation. And the literature does identify a number of features about strategic litigation that perhaps useful, often situating it as part of a wider campaign of legal, social, and political change. So that's again a useful observation. But then I just kept coming back to Mike's question, well, how is this different from the the ordinary practice of law by states. And one of the things that I guess influenced my approach is, I think there's that old saying in diplomatic circles, where you stand depends on where you sit. You know, how you see an issue is going to be very situated. And having moved from teaching in a law faculty, where even those of us who are critical scholars or those of us who are socio-legal scholars, I think there's still often this sort of tendency to kind of see the law from the inside, you know, the law as the law. Teaching international law as part of a politics and social studies school, I was suddenly having to familiarize myself, at least in a kind of tourist phrasebook way, with the language of international relations, right? So suddenly everyone's talking about statecraft, and there's the military instrument of statecraft, the economic instrument of statecraft, the diplomatic instrument of statecraft, maybe even the cultural instrument of statecraft. And the definition of statecraft is always fundamentally using your available power or resources to achieve your strategic ends, your long-term goals. And then I just found one passing reference in a colleague's book to the legal instrument of statecraft. And for me, I had a second light bulb moment going, oh, law is an instrument of statecraft, but international lawyers never talk about it that way. And international relations scholars almost never conceptualize it as part of the arsenal of statecraft. So my basic thought was, actually, the ordinary business of being an international lawyer for a government is using law to achieve your strategic ends. There isn't a dividing line where it becomes strategic litigation or lawfare. It is just one continuum. And the question should not be what is and isn't lawfare. The question should be, why is international law useful at all for small states in achieving their goals?
Fabulous. And you finished just as you raised this thorny question, right? Which is very much the content of my second question, which is, in a recent article that you published in the British Yearbook of International Law, you focus precisely, as you have been indicating, on the use of litigation as legal statecraft by small states, especially in light of what we know is very often a tendency of great or greater powers to not comply with awards of tribunals, decisions of courts, etc. You write in particularly evocatively, and I'll quote you for a second, quote, "The question for scholars of international litigation should not be why would great powers comply with the law, but instead, why do small states not capitulate without invoking it? Unless we believe that the governments of small states are naive or victims of their own lawyers, something other than compliance is at work." So, what is at work?
Thank you, and thank you for the taking the time to quote that much of my own writing back to me. So, what is at work? Well, this is, I think, again, where the basic observation from the strategic litigation literature is useful, right? Law can be part of a broader campaign for social, political, and legal change. The question is, how do you use it, and what law does role play? So to answer that question, I think there are two parts to my answer. The first is sort of outcomes oriented. What can you get from going to an international court or tribunal? And the second is, how does international legal argument work to help get you those results? So the virtue of going to an international court or tribunal, or the virtues are potentially numerous. So you're on, and some of Juliet McIntyre's work goes to this, you're on a more level playing field symbolically. That helps, that raises you to the same level as your interlocutor. But also international courts and tribunals have this reserve of legitimacy and symbolic capital that they can distribute in their decisions. And as a small state going up against a greater power, that gives you, I think, three key possible outcomes. The first is, if you're successful, you have an immediate effect on potentially delegitimizing in whole or in part your respondent state's policy or action, the thing that you're challenging. However, there's often this sort of tightly bound kind of perception of the acts and the actors at the international level. So when you challenge the legitimacy of the conduct of a state, you are also, in my terminology, potentially inflicting a legitimacy penalty on the state itself. Its own symbolic capital as a state begins to be eroded. And contrary to some of the earlier kind of rational choice type literature on international law out of the 90s, where the good stuff definitely saw that reputation could play a role. That reputational literature suggested, okay, if you lose your good reputation in a trade dispute, states might be reluctant to engage in further trade negotiations with you later. My point's actually broader. I think you lose diplomatic capital across a wider front if you're seen as acting unlawfully or lawlessly. And third, I think being successful before an international court or tribunal can help rally other similarly situated states to your cause. And that flips me to my sort of second point about how international legal argument itself allows you to do this. And this draws partly on the stuff around lawfare and insights from people like Kong-Yan Kai, but also like a fundamental point made quite some time ago by Marty Koskiniemi. What law allows you to do, particularly as a small state, is to say, the thing that's happening is not just a wrong done against us, it's an attack on a community value. And I think there are two dyads at play there. One is, as it were, individual versus the community, and the other is the political versus the legal. So very often states that want to stand back and not get involved in a dispute will go, well, this is a political dispute just between these two states. But what framing your argument as a matter of legal principle allows you to do is say, one, this is legal, not political. We're moving it out of the realm of power politics into something about principle. And two, it's not just about us, because if this could happen to us, it could happen to you as well. And therefore, you should come in behind us. Now, I'm not saying that these effects are generated uniformly in every case. Sometimes they succeed, sometimes they fail. But you can definitely see that these are rational reasons why you might try and use law as an instrument of statecraft, particularly if your other options are limited.
Absolutely. So in a way, thinking about law and litigation as a way of like making this a more universal or a more multilateral dispute,
Right.
rather than a David and Goliath sort of situation. For me, like the penny really dropped when once you were discussing with me or in front of me, I don't remember what it was, this dynamic, and you said something like, well, the really interesting question in, let's say, the South China Sea arbitration is not why China has not complied. That's pretty kind of self-evident. The really interesting question is why Vietnam and the Philippines have not backed down.
Right.
Right.
Yeah.
And suddenly, to me, it really felt like these moments of, the penny dropping and enabling me to see this in such different terms than usual, like IR realist terms treat international law, right? In which it's the great powers that are centered rather than smaller states.
Right. And that's very much what I've tried to do with this project, is sort of come to it and say, well, we always talk about the impacts of great powers on international law, or how international law is used, say, by the global north to set up a system that favors it over the global south. The other thing that we tend to center in international legal scholarship is courts and tribunals. So we'll look at the impact of great powers on the law, and then we'll say, oh, and here's the impact that courts or tribunals might have on a situation, or how their handling of certain cases might affect the legitimacy of the court or tribunal itself. The thing that seemed to me to be missing in a lot of the literature we deal with is just that perspective of the small states, the other side of the equation. why do they go to the court or tribunal? Why, as you say, why do they not back down? How can international law be used to put a thumb on the scale of international politics? So my conclusion was, you don't necessarily expect to get instant compliance,
Yes.
but you hope you can either use law and legal processes to build a supportive coalition around you, or at least to try and pressure legal and political developments in a particular direction. And I think law is sometimes useful in that regard, in kind of, how to put it, preventing backsliding, trying to make sure that the lever continues to move only in one direction, like a ratchet, and not something that swings backward and forward.
That makes perfect sense. And I think a lot of it will also make sense if we zoom in into concrete examples, right? So I know, for example, that one of your main case studies of litigation as Statecraft is the case of Mauritius against the UK. Could you tell us a little bit more about it?
Right. Well, and also this case study is, in a sense, the origin story for me of the project, right? So I applied, at some moment in the pandemic when all the dates run together for the funding that sort of got me the project I'm presently on. But I'd really been grappling with this question for about a decade before that, because in around sort of 2010, when I was working at University College London, Philippe Sands, who was working in an office across the corridor from me, sort of came and knocked on my door and went, the government of Mauritius has this legal problem, which is that at the moment of decolonisation, the UK retained part of what Mauritius believes should be its territory, the Chagos Archipelago, and it's where the US Air Force Base on Diego Garcia is, which people might remember from torture rendition flights. And he said, but if we're going to have this case heard, we need to find a forum. Can you go away and think about what the options might be? And I came back with this sort of crazy theory about challenging the UK's status as a member of the Indian Ocean Tuna Commission through a dispute resolution clause that would have got the case into the International Court of Justice, despite the UK's reservation about disputes being heard there between it and Commonwealth states, which is to say former colonies. And Philippe just came back and went, no, the current ICJ is too conservative. We're going to take it to a law of the sea arbitration. I went, oh, that sounds plausible. And he's like, and I want you to be part of the team. So I wasn't one of the kind of speaking courtroom advocates or barristers in that arbitration, but I was part of the Mauritian legal team and got to see the case, that particular element of Mauritius's campaign of what I would call legal statecraft from beginning to end. So in 2010, the Mauritius initiated this arbitration case before the UK as part of a series of cases that really ran through to at least 2021, which were aimed at bringing the question of sovereignty or jurisdiction over the Chagos Archipelago before a series of international courts and tribunals. So in that first case, I'll skip all the technicalities of the law of the sea, the arbitral award in 2015 that was handed down by a tribunal confirmed that Mauritius had, as a consequence of the manner in which it was decolonised, at the least certain rights in the archipelago that the United Kingdom had violated through declaring unilaterally a marine protected area without consulting Mauritius. Now that sounds a really narrow and technical victory, right? But of 5 arbitrators, 2 would have said, actually, the entire process of decolonisation was conducted unlawfully, and therefore, as a consequence, under the Law of the Sea Convention, the United Kingdom is not the coastal state in right of the archipelago, and it belongs to Mauritius. So there was a fair, you could take from that sort of reading of the bench that Mauritius had quite a good case in decolonisation. It had already scored this diplomatic victory with that decision in 2015 against the UK, and was then in a position to go to the UN General Assembly and, as it were, cash in those chips and say, we would like the question referred by the General Assembly of the United Nations to the International Court of Justice. So that decision that followed from the ICJ, the advisory opinion, was a stunning victory for Mauritius because it found that the UK had not complied with the law of decolonisation in the 1960s when Mauritius was granted its independence, that the Mauritian Territorial or Self-Determination Unit had in law included this quite distant archipelago that was inhabited by the Chagos Islanders, and that entire unit should have belonged to the new Mauritian state, and that the UK's continued occupation of the archipelago was unlawful and needed to come to an end. Now, again, does the UK immediately abandon its occupation? No, the UK, in fact, purports to renew its lease, sovereign lease to the United States till, I think, 2036. Nonetheless, Mauritius then takes this technically advisory opinion and initiates a maritime boundary dispute with the Maldives being the nearest coastal state to the archipelago in question, and the Maldives' first response is, Mauritius doesn't have standing to bring this case. The coastal state is in fact the United Kingdom, or there's a dispute between the UK and Mauritius as to who is sovereign there, and that is not an appropriate question to be raised in this maritime boundary dispute. To which the Special Chamber of the Tribunal for the Law of the Sea said on the preliminary question, no, ICJ advisory opinions are not without legal effect. There is no meaningful dispute as to who is truly sovereign here. We'll proceed to hear the maritime boundary dispute. So through this sort of approach, first arguing about rights in the archipelago before a Law of the Sea tribunal, then arguing about decolonisation before the International Court of Justice, they finally get, in a third proceeding, a ruling that actually says there is no meaningful legal dispute about who is sovereign. And in the meantime, based on the ICJ advisory opinion, the UN world map has changed. Various international organisations no longer recognise the Chagos Archipelago as part of the UK territory. Very amusingly, the International Postal Union will no longer accept British stamps issued from the British Indian Ocean Territory, which I'm not sure are widely used, but I think are a concern to stamp collectors. And along the way, in terms of my theory about the legitimacy fallout being potentially wider for a state, two interesting things happen to the UK. Now, there's lots of factors at play here, including Brexit, right? So the UK's international prestige in general has already been damaged by Brexit.
Doing very well, yes.
Yeah, but all of this is going on in the background as well. And two things happen. One, for the first time in the history of the International Court of Justice, or of its predecessor, the Permanent Court of International Justice, the UK judge on the court is not re-elected for a second term, and there is presently no UK judge on the court. That is definitely in part related to these proceedings, right? And the further damage on top of Brexit done to the UK's general diplomatic standing. Also, it's been said that the UK's preferred candidate for prosecutor of the International Criminal Court, they had hoped that would go through without an open election, right? That there would just be election of Karim Khan as the ICC prosecutor, as it were, by acclamation. But again, it found it did not have the diplomatic clout anymore to get its result without an open vote. It still got its preferred national up as prosecutor, but not as cleanly as it might have in a different era. And it has been announced in newspapers that Mauritius and the UK are back at the negotiating table as to the future of the archipelago. So will Mauritius get what it wants in the long run? Who knows? Have they severely limited the UK's room for legal manoeuvre? Yes. Did they get them back to the negotiating table? Yes. And has there been wider diplomatic consequences for the UK in terms of its prestige in the world and its ability to get the results it wants? I'd say arguably yes.
Yes, absolutely. And it sounds like, small states can extract some costs when it comes to non-compliance that otherwise their geopolitical power, their economic power would not allow them to extract, right? Mauritius could not very effectively adopt very impactful countermeasures,
Right.
or sanctions against the UK, right? But it can chip away some of the legitimacy using these cases and the fact that the UK so far has not been in compliance. So I will slightly change the focus here, which is and bring the conversation basically to methods of legal statecraft beyond litigation, right? And the reason I'm pivoting is I think we have been having this conversation. I often get really frustrated when I try to teach international law, and my students are very obsessed with a particular view of law that centers around domestic appellate courts, right? That law is what happens in courts, there is nothing else. You and I both know that this is not the case. So what other methods of legal statecraft are available to states, and especially to small states?
Right. Yeah, it's a good question. So, and again, some of my answers will, to some extent, focus on litigation, or at least sort of dispute settlement procedures in a broad sense. But I think there can be effects or other techniques of, as you say, using the instruments of legal statecraft. So one of them, in terms of thinking about the outcomes you might want, is changing the terms of the political debate. And I think a very good example of that is the way that a number of small island states have attempted to reframe climate negotiations. So the UN COP proceedings each year to talk about voluntary restrictions on emissions under the Paris Agreement and the Kyoto framework. And a significant source of frustration there has always been that what states kind of bring to the table in terms of voluntary anthropogenic greenhouse gas emission limitation is, well, this is what's politically feasible for us to do, or this is what we think we can do in a managed way that won't harm our economy. And what's coming to the table is, as it were, sort of business or politics as usual. And so how do you reframe that? Well, one of the things a group of states did was come together and form a miniature international organization, the Council of Small Island States on International Law and Climate Change. And they didn't attempt to sue in a state responsibility case, the big emitting states. Again, they went down this advisory opinion route and went to the International Tribunal for the Law of the Sea. So it wasn't strictly a contentious case, but the question they wanted to put to the tribunal was, what are the responsibility of states under the UN Convention on the Law of the Sea in terms of climate change? And again, the response, at least symbolically, was a stunning win, right? The boiling down a complex decision, but the tribunal essentially said in part that the obligation to protect and preserve the marine environment from pollution means that you have to take measures that are necessary according to the best available scientific evidence and in light of other international rules and standards. But crucially, that pollution of the marine environment includes the introduction of heat energy to the sea as a result of greenhouse gases and anthropogenic warming of the atmosphere and oceans. So bottom line, greenhouse gas emissions are a form of pollution. They damage the marine environment. States have a legal duty to do not what is convenient, what is necessary in light of the science to prevent damage to the marine environment. So that arms states, these small island states, in the subsequent rounds of negotiations to say, no, we're not interested in discussing business as usual. We are interested in discussing what is legally required. Now, again, is that going to change the negotiating strategy overnight of major emitting states? No. Will it change it ever? Maybe, maybe not. But does it give them more political leverage than they had before? Absolutely.
Yes.
Another possibility is simply, and this, I'll come to a particularly good quote from a friend, Professor Beck Strating, in a moment, but is kind of trapping states in their own legal rhetoric. So Professor Beck Strating has this wonderful phrase, which is that Australia's rules-based international order rhetoric has changed the behavior of no state in the world except Australia. right? So, if you wander around saying we are committed to a rules-based international order, we are committed to a free and open Indo-Pacific governed by international law, we strongly rebuke China's failure to turn up to the 2016 arbitral award process in the South China Sea. Then when Timor-Leste, with a long-running maritime boundary dispute, turns around and goes, well, we would like our dispute with you settled in accordance with international law, Australia's room for diplomatic manoeuvre becomes much more constrained as a middle power that sees itself as exerting influence through the rules. So that technique is what my colleague here, Shirley Scott, would call, the power of international law as political manoeuvring. So you have these two different ways where you can either try and use law to push political debate in a particular way, or use an opponent's own kind of legal rhetoric to kind of box them in and reduce their space for diplomatic maneuver.
That makes perfect sense. It actually ties well to my next question, because when you were saying, well, will the debate change? Who knows? Will the terms actually change? Who knows? So I want to return to this idea of like using legal statecraft to change the terms of the debate. And as you have kind of already implied, this happens, the success of these efforts varies, right? And in fact, I have seen you arguing that, as you said before, Timor-Leste was much more successful in using this technique vis-a-vis Australia in comparison to the Philippines and Vietnam using this technique vis-a-vis China in the South China Sea. So basically, my question is, how can you explain what determines if this change of terms will actually take place?
Right. Well, all of these things are a kind of multi-causal environment, right? So, you have 3 or 4 factors at play and get to desired outcome A, or you don't get to desired outcome A. Which factor was decisive? Well, possibly none of them, right? Possibly they only work cumulatively. So if you look at sort of the differences between the Australian situation and China in the South China Sea, in some ways they're quite similar. So Australia resisted for a very long time, concluding a final maritime boundary with Timor-Leste because it wanted to cling to a sort of outdated concept of having jurisdiction in the continental shelf to the outer edge of the margin, even if that passes the median point, the halfway point between 2 coastal states. And there was old law up to about the late 1960s that sort of supported that proposition. But the bottom line was, if Australia refused to negotiate and clung to an increasingly outdated legal position, it could say it got more of the continental shelf than a classic median line maritime boundary delimitation would get it. And this looks like, in a sense, a resource grab at sea. Similarly, in the South China Sea, you see China sort of drawing a huge 9-dash line and going, everything within this is ours. And what does that get us? Oh, it gets us control of some of the world's most important fish stocks. And we're going to have this long-running fight with Vietnam about who's allowed to explore and drill for oil off its coast. So again, it looks like a resource grab. Why does Australia backtrack and come to a final maritime boundary in accordance with international law with Timor-Leste and China does not? I think there's a mix of different things. One, obviously, a great power, a truly great power like China or the United States can attempt to tough it out, right? They can just say, nope, we think if we hold our position long enough, eventually everyone else will fold. And Australia, even given the power disparity between Timor-Leste in itself, maybe doesn't have that kind of very long strategic patience, although arguably it had exercised that kind of patience for a number of decades in the dispute. Secondly, there was a substantial public interest in the issue within Australia. So, Timor-Leste had done a very good job over a very long time building support for its cause within Australia. So, free East Timor protests were definitely a thing when I was in high school or an undergraduate in Australia. And I remember the Timorese independence referendum and the Australian military commitment to the Transitional Government and Stabilisation Task Force around that time. So there were these sort of strong people-to-people links in play as well. Also, Australia was trying to shore up its relationship with small states and small powers in the Pacific in the face of increasing Chinese influence in the region. And there's only so much, bad press you can take in your relationship with a similarly situated state when you're trying to say to everyone else, no, wait, we're the good guys, and you want to sign up with our team. So I think you had these various things happening at the same time. One, rhetorical entrapment. Australia had said, we do things by the rules, we're a good faith actor. And Timor-Leste was able to stand there on the sidelines and go, really? Really? You had this strong kind of political constituency and base for the East Timorese within Australia. And then you had this wider geopolitical context. And suddenly, once all of those things come together and, Timor-Leste ramped the pressure up. It had started a number of international arbitrations against Australia. There was the scandal over the fact that we had spied on the Timorese cabinet room during negotiations for one of the joint development agreements for offshore oil and gas, so that we were negotiating at a severe advantage with the Timorese. So all of these factors were in play, and I think Australia did gain a lot of diplomatic upside, actually. So the reverse of the legitimacy penalty, by essentially coming to the table and negotiating with Timor-Leste and resolving this long-running dispute, suddenly I think Australia was seen by small states in the region as a good faith actor again, in a way that either it hadn't been or where its reputation was in doubt.
Right, that makes sense. So when the stronger power actually perceives these losses as being substantial enough to bring them back into both the negotiating table, but to the language of the law. That does make sense. So final question. There is the flip side of the story, right? And there is the strategies that great powers use, the legal strategies that great powers use against small states. And in particular, you have used the term of strategic fragmentation in relationship to the law of the sea to describe this counter move by powerful states, I imagine, especially by China. Do you want to tell us a little bit more? What do you mean by that?
Right. So I think I've got one particular example in mind here, and it is indeed China. So, we have the South China Sea arbitration, which essentially, again, to kind of simplify, there were two Chinese scholars writing in the American Journal of International Law, Gao and Bingbing Jia, said in, I think it was 2013, look, China has never clearly articulated what the legal basis for the 9-dash line is, but it's either a set of historic rights from long historic Chinese use of these waters, or it's about saying various features inside this line, they're all ours, and enough of them are islands that they generate 200 nautical maritime zones, and the rough delimitation you get corresponds with this line, or it's both. So, it's either claims that these things are islands generating 200 nautical mile zones, or historic rights, or the two in combination. And the 2016 arbitral award basically shoots both of those arguments down, right? It goes, you can't have special historic rights that exceed the rights given to you by UNCLOS. The convention doesn't recognize historic rights. It only recognizes historic waters, which is a sort of special category that applies to certain small areas of the sea, basically straits and bays, and will treat them as internal waters in a way where they might not otherwise be treated. And then they said there are no features in the Spratly Islands, though they're called islands, we hold that none of them are islands in law, generating 200 nautical mile territorial seas. They're all little bits of reef that maybe stick above the water at low tide, or they're rocks continuously above high tide, but at most that generates a 12 nautical mile territorial sea. So there's nothing here to delimit. Okay, so what does China do in response? It does not back down. It does not abandon expressly any of those arguments, but a very interesting legal strategy emerges, which I've called strategic fragmentation. And this is sort of a 2 or 3 step process. The first step is to go, despite the fact that everyone's called it a constitution for the oceans, despite the fact that it runs to over 300 articles, multiple annexes, and 2 implementing agreements, the Law of the Sea Convention is not comprehensive. It has gaps. So step 1, we assert that there are gaps in the Law of the Sea Convention. Step 2, if there are gaps, they could be filled by customary international law. Step 3, we think there is a special rule of the law of the sea. So the convention says that states composed entirely of islands can declare themselves archipelagic states and draw straight baselines around their maritime boundaries and project their zones from those boundaries. We think there's a customary international law rule that allows us to draw, that would allow us to draw straight baselines around our offshore island clusters and project full 200 nautical mile zones from them. So suddenly, voila, the Spratly Islands are an offshore archipelago. We could enclose them in baselines and project zones from them. And magically, we're back at the position we started from. Everything within the 9-dash line is ours. So it's a form of legal argument, right? There's not a reliance on mere power. There is an attempt to make a legal argument. The legal argument is strategic in nature. They're still trying to gain the legitimacy of law for their claims, but it is based on trying to drive wedges into what was conceived of originally as a kind of comprehensive legal structure and say, we can open up these gaps, we can pioneer new norms to fill those gaps, and then the result will favor us. Now, just to be kind of fair to the Chinese position, it's not like China has never spoken before about offshore archipelagos being a special case. There was some support that China advocated for that during the Law of the Sea negotiations, but it was pretty clear to everyone that that position was abandoned, and not just by China. Like, there are other states that are continental states that have a lot of islands, Greece being a major example. And everyone was very aware during the Law of the Sea negotiations that they were giving up this argument and only allowing it to be applied to archipelagic states. And that was a position China supported at the time because it wanted to be a leader of the developing world, which included the archipelagic states. But so the thing I find that's interesting about this is it's definitely a type of norm entrepreneurship, right? It is not an abandonment of the law. It is an attempt to engineer new rules and inject them into the law. But the reason why I don't see it working is because to take a different great power that engineered a new norm, when the United States decided to assert resource jurisdiction over the continental shelf with the Truman Proclamation in 1945, it put forward a rule and expressly said, while we assert that we have jurisdiction over the continental shelf as the natural prolongation of our land territory and exclusive rights to exploit those resources, we will acknowledge the equal rights of any other state to make the same claim that has a coastline and a geological continental shelf. The rule was capable of being invoked reciprocally. China is presently trying to put forward a rule that really only benefits it. I mean, it can point at other states that have done some dodgy stuff with straight baselines around outlying archipelagos like the Canary Islands, Svalbard, and the Falkland Islands. But strangely enough, those states are not rushing to support China's claim that this is a legitimate use of a marginal rule of international law, if it has any legal status at all.
Fantastic. I need to go back to my law of the sea. I have to say, for the benefit of the listeners, at some points I was looking at DAG quite confused, but I will go back and draw. Oh, no, not your fault at all, Dag. It's just I was a very non-studious law of the sea student in my undergrad.
Well, also, in fairness, anytime I try and explain this stuff, I usually have maps, but we've already explored the limits of podcasting as a visual medium.
That's exactly right.
But just to sum up on that briefly, I mean, the idea of strategic fragmentation is not, it's not a wholly kind of unique or nifty idea I've come up with. I'm sort of drawing on two literatures. So, I mean, we've talked for a long time about the risks of fragmentation in international law, that, you could have rules growing up in silos and conflicting with each other. And we've got Surabhi Ranganathan's excellent book, Strategically Created Treaty Conflicts in International Law, where states will deliberately engineer rules that clash to try and get to a political result they want. And I think this is just a sort of mishmash of those two approaches, right? It doesn't involve the creation of new treaties, but it does involve the creation of conflicting norms to try and get the law to a point that favors you.
Makes sense. Makes a lot of sense.
So look, Ntina, I've been talking at you a lot and gesticulating and failing to draw maps. But in the tradition of table turning in this podcast, my question for you is, you've spent a lot of time thinking about the use of international law to create and reinforce hierarchies. And so my question really is, how much space do you think small states actually have to push back from within that legal order? And I'm thinking particularly here of, your writing that I found very helpful in this project of mine on the Southwest Africa cases.
Thank you. Thanks for saying that. So I would say as a true lawyer, the answer is it depends. That's the only correct answer. So I would say, more than looking into the small states, I think it might be helpful to figure out what political end are they arguing for, and whether correspondingly the legal arguments that they're trying to make are legal arguments that can avail themselves to the sort of political ends they're trying to put forward, right? And my relatively pessimistic outlook in the Southwest Africa cases was, first, because I'm a Crete and we have to be pessimistic, but more importantly, because I think they were trying to make the League of Nations system, the League of Nations mandate system, and especially they were trying to make the so-called sacred trust of civilization that formed the base of this mandate system, to do not just something different to what it was designed to do, it was trying to make it do the exact opposite of what it was designed to do. It was trying to make it a vehicle for arguing for the international unlawfulness of basically the particularly aggressive form of racial capitalism that apartheid South Africa had installed in Southwest Africa, right? And even though at the end, in the final advisory opinion, they did manage to get a win, they had to, in order to get that win, they basically had to narrow down very substantially the terms of the debate, right? It wasn't about racial capitalism anymore. It was about legalized open racial discrimination against particular individuals, right? So you move from a sort of a radical anti-racist agenda to, let's say, a liberal anti-racist agenda. So the answer is a little bit like, it depends what you're trying to get out of the law. And I would say, in certain cases, the law will be much more receptive towards the interest of small states. Whereas if they're trying to go against not only just dominant powers, but I would say the structuring features of international order as a whole, rather than this or that great power, international law starts becoming more and more of an, unreliable tool in that political struggle.
Right. No, that does make sense, that there's only so far you can push an argument against the grain,
Yes.
and that argumentative framing will push certain things out of the picture. And perhaps from that point of view, it's sort of an example of rhetorical capture, or the flip side of rhetorical capture, right? So in my Australia Timor-Leste example, Timor-Leste was able to say, well, you've got to live up to the standards you're articulating. And here, as you say, in a sense, you have to abandon a number of your principles to fit what's left of your argument within the legal space. But I do wonder if, there are also historical tides in this, right?
Yeah.
And it's interesting to kind of think that for so long, there was pessimism on the critical side about what international law can do. Have you had to find a more kind of optimistic side to yourself when you look at current ICJ cases? Because I forget who said it recently. It may have been you, or it may have been someone else, but our textbooks all used to say, oh, well, self-determination, we're not going to talk about it very much because it's all over and done with. And suddenly every major case in the international space is invoking self-determination. And we've got, an international court of justice, one of the most conservative decision-making bodies in international law, coming within a whisker of finding that Israel was an apartheid state, but instead saying, well, there are violations of Article 3 on racial segregation or apartheid. But still, that's a lot. That would have been unimaginable 20 or 30 years ago. So are you being forced to be a little more optimistic?
I mean, I'm pessimistic about the state of the world, but yes, you're absolutely right. And I do have to say it, right? And I'm very happy to admit that publicly. I did not think, with 8 hours to go before the publication of the advisory opinion, my hot take in the number of WhatsApp groups was, oh, they're not going to say much. And I was wrong. I was absolutely wrong. And that makes me also very optimistic, for example, about the climate change advisory opinion that is going probably to come out sometime next year, right? I do think, as you implied before, also when you were mentioning Mauritius, there is a particular bench currently. And also, I think there is the precedent of the Mauritius, not the Mauritius, of the Chagos Islands advisory opinion that I think said a number of very progressive and very daring and correct, for that matter, things about the law of decolonization that I think it would incur a very great legitimacy cost to the court to walk back from it, right? Not that I think they want to, but I think it just has created a certain argumentative framework for the court that when it comes to the law of decolonization, I agree entirely with you. It has pushed at least the ICJ towards a progressive direction that I did not expect. So yeah, absolutely. And mea culpa, 100%. To those people in the chats that I was like, they're not going to say anything, I was wrong. I'll wrap up because I admitted that I was wrong, and I don't do that very often. So wrapping up, we traditionally ask 3 questions of the co-host. First and foremost, what recommendations do you have for anyone who would like to know more about what we have discussed today?
Right. I mean, obviously, there's a lot out there on the South China Sea dispute. Obviously, I'll include in the show notes a link to my paper on litigation of statecraft that you've had a very generous discussion with me about today. But I think if you want a sort of general introduction to what China is doing in a law of the sea space, it's written from a political science perspective, but it's very accessible. Isaac Carden has a great book with Yale University Press, China's Law of the Sea, The New Rules of Maritime Order. And it actually provides a very accessible first principles introduction to international law as well along the way, but has a very kind of clear-eyed approach to how China addresses these issues. And also early in this project, with another one of your hats on, you edited a collection of blog posts on small states and their international disputes for CIL dialogues out of the National University Singapore Centre for International Law. So we'll include that too. But also, I'd say that I think if one's thinking about sort of China, its relationship to international law, I've learnt a lot from Kongyang Kai's book on the rise of China and international law. So I'm sure I could keep recommending things all day. Oh, and if one's interested in particular in lawfare, I think one of the people doing really interesting work on that from an American perspective at the moment is Jill Goldenseal, and I'll link to one of her articles as well.
Awesome. So I'll start moving us away from international law. The next question is, what is your current escape route? What are you doing on reading or viewing that takes your mind off international law?
Well, I've first got an answer that isn't actually a completely honest one, because it didn't totally take my mind off international law. But I think I've probably mentioned my fondness for board games in earlier episodes. And indeed, Ntina, we've played many a board game together over time, and you introduced my family to Settlers of Catan. A good exploration of colonial practices and terra nullius. But I was recently doing a training exercise for government officials, and I thought the best way to illustrate some concepts of law of the sea and maritime domain awareness and how hard it is to find things at sea would be to make a board game. I've spent quite a bit of time creating Maritime Domain Awareness, the board game. There are some images on Twitter, and unfortunately, it probably won't be coming to a shop anywhere near you anytime soon, but it went over very well in training.
Yes, never know. I think we're truly living in the golden era of board games, so maybe. And finally, traditional question of the pod, an important question of the pod, because it's not a visual medium. Doug, what are you wearing today?
So, as we were discussing before we started recording, my life has been changed by Derek Guy, the fashion guy on Twitter,
Yes.
who, when he's not ripping through celebrities' fashion disasters, dispenses a lot of very sensible advice. So I had some neighborhood tailors make me some very comfortable green corduroy trousers that I'm presently wearing. But the reason they're so comfortable is they sit at my natural waist, and I'm wearing them with suspenders. So I'm not kind of strapping a garment to my body with the tourniquet, generally known as a belt. And I've paired that today with a vintage green and blue paisley tie by Kenzo that I think I got off eBay. And because I'm sitting in Canberra, I have some very fetching little cufflinks that have the ACT government, the Australian Capital Territory government coat of arms, which I think have been clipped off an old stamp.
Okay, I cannot see them, but everything else I can confirm. Okay, thank you very much, Doug. Thanks to everyone for listening. More from us soon.
Thanks, everyone, and bye-bye.
Bye-bye.